Hello everyone, and welcome to the second of our video tutorials on the judiciary. In this video we're going to be looking at the appointment of judges. The qualifications required for all of the different types of judges are set out in the Courts and Legal Services Act 1990 as amended by the Tribunals, Courts and Enforcement Act of 2007. Qualifications to become a judge are based on legal qualifications plus relevant legal experience for a number of years, and candidates need between 5 and 7 post-qualification experience, which we call PQE, to become a judge. And it's important to recognise that the system for selecting and appointing judges has changed in recent years. Up to 2005, selection of superior judges was done by the Lord Chancellor, and this system was quite secretive. And in addition, the Lord Chancellor is a political appointment, which meant that the selection of judges wasn't independent from political influence. And that was seen as conflicting with separation of powers. So for that reason, the CRA, the Constitutional Reform Act, which if you recall also created the Supreme Court to replace the House of Lords as the highest court in the UK, the CRA changed the way that judges are appointed and created the Judicial Appointments Commission, or the JAC, to deal with the selection of judges. And you can see on this slide here that the CRA made significant changes to the role of the Lord Chancellor, changed what the Lord Chancellor used to do, and now you can see here on this side that the Lord Chancellor is head of the Ministry for Justice, and he's also responsible for legal aid, which we will look at in our topic, Access to Justice. So as well as limiting the role of the Lord Chancellor in the appointment process, the CRA also created the JAC, the Judicial Appointments Commission, to bring independence to judicial selection. And the Commission is an executive, non-departmental public body sponsored by the Ministry of Justice. And the JAC selects candidates for judicial office through fair and open competition. They recommend but don't appoint. JAC selects candidates solely on merit, people of good character, and it also tries to encourage diversity, which has been a problem for our judiciary in the past. The Commission, as you can see here, recommends 5 judicial qualities which it says are essential to be a good judge. So intellectual capacity, integrity, independence of mind, ability to understand and deal fairly, authority and communication skills, and efficiency. In terms of the selection process, all candidates have to fill in an application form, and candidates are also asked to nominate between 3 and 6 referees. For all judicial posts below that of a circuit judge, there's an extra filtering process, and all applicants must do an online qualifying test at the start of their application. And these tests are designed to assess the candidate's ability to perform judicial roles. Candidates are then shortlisted on the basis of their performance on these tests, along with their online application form and their qualifications. A shortlist will then be made of candidates, and these will be interviewed, and the interview process may include role play or taking part in formal, structured discussions. And the Commission then selects those to be appointed and recommends them to the Lord Chancellor for appointment. Once a candidate has been selected, the appointment is made by the Queen. This keeps the selection and appointment process separate from the government, which is important for judicial independence, which we'll come back to later. JAC doesn't appoint judges to the Supreme Court though. Under Section 23 of the CRA 2005, to qualify for appointment to the Supreme Court, a judge must have held high judicial office for at least 2 years or been a qualifying practitioner for at least 15 years in, for example, the Court of Appeal. 12 judges are appointed to the Supreme Court by the Queen on the recommendation of the Prime Minister. The Lord Chancellor recommends these judges to the Prime Minister following a selection commission set up by the Lord Chancellor. The Senior Lord of Appeal is called the President of the Court, and we know that at the moment that is Lord Reed. In terms of evaluating and criticising the appointment process, in the past, the diversity of the bench has been a huge criticism. Hopefully the JAC is starting to address that, but the diversity of our judges is still a problem. And the issue of diversity is really important because we live in a multicultural society, and the judiciary should aim to be reflective of society as a whole. But unfortunately, judges are generally old, white, rich, middle upper class men with a public school education, which only really represents a very small part of society. And there's a suggestion that maybe judges might have a political bias, with judges being pro-establishment and overtly conservative. Although obviously a fairly recent judgment by Brenda Hale against the Prime Minister would undermine that argument. There is discussion about possible sex discrimination on the bench. The Association of Women Barristers blame figures on what they describe as the old boys network. And so a more diverse judiciary would improve public trust and confidence in the justice system. And as I've said, we've got a better appointments process now that we have the JAC, and it will take time for the makeup of the judiciary to become more representative of its people. Barriers to education and jobs in the law need to be removed to help us to get a more diverse judiciary. And if we just have a look at the composition of the bench then, so that you can see what I'm talking about, this narrow socioeconomic group. These statistics I've taken from the Judiciary website, and they are from July 2019. And you can see here that 32% of our judges are female. So that's a bit disappointing in itself, because you'd be hoping for roughly 50-50 male to female judges. But more worrying here, 7% of judges are from ethnic minority backgrounds. And that is incredibly low and something that we need to tackle. 21% of Court of Appeal judges are female, 21% of High Court judges are female. Again, women being not represented as well as they arguably should be in the higher courts. So whilst we have female judges in the lower or inferior judicial roles, they're not appearing as representative in the higher courts. You can see here as well, 33% of judges are from non-barrister backgrounds. So that means most of our judges were barristers first rather than solicitors. And actually the statistics show that judges in the lower courts are more likely to come from a non-barrister background. This statistic from July said that there were 3 female justices of the Supreme Court, and I've mentioned Brenda Hale there, personal hero of mine. She's actually since retired from the Supreme Court. So I'll take her name off there, sadly. In order to tackle this lack of diversity on the bench, the JAC does have some new initiatives to try and increase judicial diversity. They've got the Diversity Support Initiative to attract more high-quality lawyers and legal academics from non-traditional backgrounds, i.e. non-barrister backgrounds as well, perhaps. They've also got a judicial mentoring scheme, which focuses on addressing underrepresentation of women and Black, Asian and minority ethnic lawyers to try and encourage greater socioeconomic diversity. And they also have a judicial work shadowing scheme to try and give people an insight into judicial office, to try and encourage people, perhaps from different backgrounds, to start a career as a judge. So once they're appointed, you need to be aware of training, the training that judges receive. The Judicial College is directly responsible for training full and part-time judges in the courts in England and Wales, and for training judges and members of tribunals. And the Judicial College is also responsible, we know, for overseeing the training of magistrates. And the Judicial College has identified these 3 key elements to judicial training, which you can see focus on their knowledge of the law, the acquisition and improvement of their judicial skills, and also the social context in which judging occurs, so becoming socially aware. So now we've looked at appointment, let's just consider dismissal and something called security of tenure. So judges have security of tenure, which means that it's very difficult to sack them. And this is to ensure the independence of the judiciary. And if you think back to what I said at the beginning, it's very important that judges should be impartial in their decisions, and in particular that the government cannot force a judge to resign if that judge makes a decision with which the government of the day disagrees. And this ensures that we have independence of the judiciary, which we'll look at a bit more closely in our next video tutorial. But if again you think back to that case or on the application of Miller and the Prime Minister, it was really important that Brenda Hale felt able to make what was going to be an unpopular decision, potentially declaring that the Prime Minister had acted unlawfully, but that she felt able to do that on the basis of the law without fear of being sacked. Judges retire at the age of 70, and you can see here that superior judges cannot be removed by the Lord Chancellor or the government, and that is, as I said, to give us independence of the judiciary. For inferior judges, the Lord Chancellor does have the power to remove them for incapacity, meaning they're no longer able to do the job anymore, perhaps they've become very frail, or misbehaviour. And you might want to have a look in some newspaper articles, see if you can find some cases where judges have been criticised for things like falling asleep during trials and things like that. So they could be dismissed for misbehaviour. But in general, as I've said, judges have security of tenure to ensure independence of the judiciary. And we're going to look at that concept in our next video tutorial.